All right, we are back with another update. Doug, Rohan Law, still covering this FSU ACC saga, and again, third update I think we're doing, and this may be like the third of 20 after the year is up. So we'll see. Doug, thank you for jumping on. We'll jump right into it. The ACC updated their complaint. They amended their filing against FSU or toward FSU today. Maybe came as a surprise, maybe not a huge surprise. How often do you see that? Like where like it was Florida State's like the ball was kind of in their court, right? To respond. And the ACC went ahead and updated their filing before Florida State obviously had responded. Any just general thoughts on that before we kind of dive into the 6 complaints?
No, this can be very standard. It happens a lot in lawsuits where you file an amended complaint. Essentially, you come up with some additional theories. Maybe you want to include some additional parties. So filing an amended complaint in and of itself is not unusual. Again, what we have here, though, is a situation where the ACC filed before FSU filed initially. So now they're trying to bolster their breach of contract complaint, saying that, see, we told you that this was what FSU was going to file, and then they did. Once FSU filed their complaint in Florida court, then the ACC had some more meat to go back and clarify some of their positions, some of their views. So it's not an answer to their own complaint or to the Florida State complaint in Florida. This is their way of just kind of clarifying what they see as the primary issues in their complaint in North Carolina.
So if you haven't seen the first couple of videos, I will link them on a playlist above. You can go check those out so you can kind of not be, in the dark about some of the stuff we'll talk about. If you want to watch it after this, it may close some loops that we may kind of leave open, but those are available for you if you need them. So let's run through the 6 claims for relief. Before we do that, what does that mean? A claim for relief?
That's what you're asking the judge to order. You want the judge to decide certain issues at controversy. So here they're clarifying what are the specific issues that we want you, the judge, to rule on.
First claim for relief, request for declaratory judgment that the grant of rights and amended grant of rights are valid, enforceable contracts.
So that's echoing their original complaint where they're saying, look, the baseline of this issue is the grant of rights enforceable? Is the contract with Florida State enforceable? Does Florida State have to respect both the grant of rights and their contract with the ACC?
If they were to get relief on that, that doesn't necessarily mean that Florida State still can't challenge the agreement, or does it? Does that mean like, yeah, is that like taking into totality, or is it just saying like, yeah, it's a good contract?
As we discussed in our first video, the action that was filed, the declaratory judgment action, is an opportunity for you to find out what would a judge say if we breached the contract. And that goes to one of the other problems with the ACC amended complaint is that the contract hasn't actually been breached yet. Now, they make some other allegations, and we'll talk about the word of the day, estoppel, in a moment. But for right now, both parties are trying to get a judge to say, look, is the grant of rights does it carry as much weight as the ACC thinks it does, or is it as invalid as Florida State thinks it is?
Second one, we'll go to that point that you made about an estoppel. Florida State is estopped by its acceptance of benefits or has waived its conduct in any challenge to the grant of rights and amended grant of rights.
So what the ACC is trying to say here is, look, the FSU and the Board of Trustees have benefited from this contract. They have earned monies from the contract, and they can't now say then that this is an invalid contract because they've already benefited from them. There are some occasions where something like that might be valid. I'll pay you $1 million if you do X. You can't accept the $1 million and say, oh, no, I'm not going to do X because the contract's invalid. You've already received the $1 million. But in this case, again, the grant of rights is prospective, looking forward into the future, and Florida State hasn't received those monies yet. So again, this is another, what I believe to be a relatively weak argument from the ACC.
Yeah, it's basically we'll pay you X if you do Y every single year. Well, we've done Y and they've done X every year. We're just talking about going forward. We want to stop it going forward. Yeah, so like it wasn't a lump sum at the beginning. Number 3, Florida State has breached its promises in the GRR and the amended grant of rights agreement. It's pretty general there. And Florida State, I mean, I guess that's for a judge to determine, right? But it seems fairly vague as to whether or not, I mean, have they truly breached yet? What is it? How does a judge interpret that?
Well, there is a part of it, and that's, I went to the Mecklenburg County Courthouse website to try and download the PDF. It was filed at 4:15 today. The PDF hasn't been scanned in and uploaded yet, so we're only going off of the tweets from Peter Thamel over at ESPN. But based on what he's sharing and what he's showing, I think this relates back to that original clause where the ACC put in the contract that none of the members would ever challenge the grant of rights. And as I said in the last show, I think that of the arguments being made, that is the weakest, because you can't stop somebody from challenging what is otherwise a legally invalid contract. So FSU is arguing that the contract is invalid, therefore there is no breach that is taking place because the contract in and of itself is invalid, the grant of rights in and of itself is invalid. So any contract that says you can't sue this body for the contract that you've entered in is a very weak argument. The strongest reason for ever including that in an argument is that if somebody does have a frivolous or unreasonable reason for breaching it, you can then point back to that phrase to really tag somebody on some attorney's fees. So you can say, look, you knew that you were signing this contract. We told you not to challenge this contract. You challenged this contract. Now we're not going to feel bad about coming after you for our attorney's fees.
Yeah, that makes sense. The fourth claim is that Florida State has breached its obligation to protect confidential information. Again, without knowing all the details and everything just yet, what are thoughts around that?
Well, you can compare and contrast the two original filings. When the ACC filed their declaratory judgment action, they filed several exhibits under seal. And what that means is they've provided that document to the courthouse, they've provided it to the opposing party, but they're not going to make it a part of the otherwise commonly public records that are available. So they've asked the judge to file those and keep them sealed. What they're doing now is reiterating Florida State filed their complaint for declaratory judgment action, and they didn't keep anything back. So all of the stuff that they put in the public domain has harmed the ACC. That's what they're alleging here.
The fifth claim, Florida State has breached and continues to breach its fiduciary obligations to the conference under the ACC's Constitution and bylaws and North Carolina law.
So this one is borderline laughable to me because what they're trying to do is project. The ACC absolutely took on a fiduciary responsibility when they took the grant of rights and those licenses from each of the member universities to negotiate with ESPN. ACC is now trying to say that Florida State has some kind of fiduciary duty to the ACC, which they don't outline. Again, we haven't seen the full complaint. It is allegedly, I think, 150 pages. But without any clarification or specification, how can you say that the member institution has a fiduciary duty to the conference? It's the entire argument for the breach or for getting out of this contract is that the ACC is the one that had a fiduciary duty, and they're the ones that breached that fiduciary duty.
Yeah. And then the last one, Florida State has breached its obligation of good faith and fair dealing under the ACC's Constitution and bylaws.
And to which FSU is going to say, yeah, so what? This is exactly why we're here, because the ACC
We disagree.
the ACC neglected to do their part. So yeah, we're going to come out and talk bad about the ACC. We've told you for a year we were going to talk bad about the ACC. We gave you every opportunity behind closed doors in a civilized conference room to talk about these issues, and you ignored us. So now we have no choice but to bring it out into the light. And again, I don't think that there's much merit to that part of the complaint.
February 16th is a date that's been tossed around. An answer is kind of due here by February 16th, 30 days from tonight. We'll put this out tonight almost immediately when we finish recording. So who's that answer due from? Is that answer, does Florida State need to respond there? Is that for the judge to decide these 6 claims? What is the answer that we're looking for?
So both parties have filed mutual filings in the opposing court and agreed as joint parties that both sets of answers would be due in each courtroom for February 16th. Now, it's a very standard process that, especially in a high-profile case like this, that you just clarify exactly what is due and when it's due. And we talked about that in the last video about a scheduling order, and that's likely to continue later on if this goes into discovery. But before, we didn't know exactly what the the deadlines were going to be. And now, based on the reporting from the AP, Chris Nee over at Noles 247, we do and can confirm that the filings in both courts show that the answers are due February 16th.
If and when a judge decides on these 6 claims, and would certain claims kind of hold more or less weight? Like what if the ACC goes, best case, middle case, worst case, right? If they go 6 for 6, what if they go 0 for 6? What if they go 2 for 6 on these and a judge agrees with them on, all, nothing, or some?
Well, what you're wanting the judge to decide in each of these cases is in favor of your position. And both positions are regarding the grant of rights. The North Carolina filing wants the ACC, or the ACC wants the judge to say the grant of rights is valid. And the Florida filing in Florida State wants the judge to say that the grant of rights is not valid. Both of those then have 6, 7, 8, 10 reasons why those positions should be upheld. And they give the judge a reason to find one way or the other. So each judge then will say, yes, I agree the grant of rights is valid or is not valid, and here are the reasons why. And it's very rare that any party wins on all of their issues or on all of their reasoning, but you're trying to give the judge multiple reasons why your position is the correct position, and then ultimately in an order that's issued, the judge will say, yes, you win, and you win because of this point or because of these points.
So I've seen some people speculate that they think that this is more or less likely to end up in a settlement now that this amendment has come out. Like, do you buy any of that? Or is it, like you said at the beginning, is this really just them clarifying their points? Or do you feel like a settlement may be more or less likely at this point? Or are we kind of in the same spot that we've been in?
I think what I take from this is that the ACC is panicking to some degree. I think that they are coming at this from a position of weakness. More important than these filings that they've made today, they're asking the judge, among those issues, to enjoin or stop Florida State from doing certain things during the pendency of this litigation. So you've read off what the 6 points are in the ultimate goal, the war that they're trying to win. But in several battles leading up to that, they're asking Florida State to not be able to act as a member within the conference voting on conference issues, that they're to be stopped from participating in any negotiations, discussions, votes, things like that. So what I think that's doing more than anything is the ACC is trying to draw a line in the sand and discourage these other members who may be contemplating filing suit from joining in also. Now they not only have to worry about, okay, is the grant of rights going to be upheld or not, but the ACC is trying to claim that the FSU is going to be responsible for attorney's fees. Now FSU is going to be responsible for all of the harm that they've caused from breaching the agreement not to sue them. And more importantly, this is one that's starting to pop up. I feel comfortable mentioning it now. I wasn't going to mention it earlier because I don't want to give the other side any ideas, but several people have mentioned it on Twitter. So the question of that extension from ESPN beyond 2026. ESPN hasn't exercised the 2026 through 2036 or 2027 through 2036 provisions. Now with this litigation, ESPN very likely is going to sit back and say, maybe we shouldn't exercise. That, I think, actually has now created the strongest argument on the ACC sides about the economic damage that this litigation is causing. So for what it's worth, I think that tidbit coming to light last time might actually be the one thing that the ACC can hang its hat on. But ultimately, what this filing tells me is that they are working towards some resolution, some settlement. They're just trying to gain the strongest positioning they can to make that as valuable as possible.
If it made it to court, would an ESPN representative have to come testify to that fact? Hey, we're not renewing because of this? Like, or can you speculate on that kind of stuff?
I think that would be one of the important issues here, especially with this additional complaint or clarification filed by the ACC in their amended complaint. Any fact witnesses that are available to talk about the issues would be called upon. First, they'll be deposed likely, but they would be called upon to testify exactly to those facts that the ACC is trying to prove. Now, likewise, Florida State can bring all of its expert witnesses to show how the contract favored ESPN and was not keeping up with the economic realities of broadcast rights. So there will be lots of witnesses involved if this is something that does eventually go to trial.
So we get answers in 30-ish days based
Mm-hmm.
on when somebody's watching this. At that time, is that likely when a judge would kind of start that scheduling process that we talked about, whether it be a complex or pretty straightforward, or like how is that kind of when we would kind of have a little bit more of a date around when this might take place?
It won't be immediately after, but sometime in the very short time period after answers are filed, yes, the judge would issue a scheduling order of when discovery is to take place, what deadlines are supposed to be met. And as we mentioned before, that really is a process that could take months, not weeks or days.
Yeah. Doug, anything else we're missing on this? We'll certainly jump back on, but anything else we haven't covered just from Pete's tweets, anything you've seen from Chris or anybody else tonight?
No, I think it's very interesting and fascinating. We still haven't addressed the jurisdiction and venue issues. Again, the ACC was silent from what we've seen so far in the public domain about trying to shore up any jurisdiction or venue issues. So I think that might lend credence to what we were saying before about it being more likely that this ends up in Florida. But litigation oftentimes just comes with posturing and trying to put the case in the best light possible for an ultimate settlement that should be understood and interpreted by everybody for exactly what it means. They're not going to always say everything, and a lot of times they're going to say a lot of things that don't matter. So don't hang on every word of these complaints. Don't hang on everything that's being said, because just because something was filed, that in and of itself doesn't make it true. You'll have to see what the facts and evidence are at the trial.
Yeah. Well, Doug, I appreciate you a ton for coming on here and chatting with us again. I probably got 15 questions. I know you did too. And so happy to jump on and do this quickly. I am very confident it will not be the last time. But I appreciate it a ton. Tell everybody one more time, just a little bit about Rohan Law and maybe a little bit about yourself as well. I know you Florida State alum, all that elevator pitch that you have, and we'll wrap up and get out of here.
Well, I love coming on and talking with your viewers and making sure that everybody's educated on this process. At Rohan Law, we handle personal injury, workers' comp, criminal defense, primarily in the Atlanta area. So really, we're advertising and working towards getting to know more of the Atlanta Seminole Club and Atlanta Seminole Boosters. So, of course, if anybody in Georgia ever needs anything, we're here to help out. But yeah, I was a marching chief for 4 years, stuck around for law school, spent 7 years in Tallahassee. It's my home away from home. Try to go back for as many games as possible, send the marching chiefs to every away game. We need to make sure that endowment gets filled. But I just love FSU and I love this issue. So I love getting into it, getting up to speed on it, and making sure that others understand it as well.
Awesome. Doug, I appreciate it. To everybody watching, you can click either video on the screen right now. Those are the two previous conversations that I had with Doug, but we will talk to you guys soon and keep covering this thing. I appreciate you, Doug.
Thank you, guys. Take care.
Thanks,
Bye.
buddy.